Greetings to everyone. My name is Ankit Malhotra. I am the co-founder and president of the General Society of International Law. Today amongst us, we have a stalwart of the British and the international legal fraternity. Before I introduce her and her topic, let me share a few words about the Center for Study of United Nations, the General Society of International Law, and this lecture series. The Center for UN Studies was or has an aim which seeks to develop a learning platform on opportunities and limits of the United Nations by enhancing research and building knowledge on how the United Nations systems work, both in terms of institutional development and in terms of promotion and implementation of various multilateral policies. The center fits well with the global vision and aspirations of the General Global Law School and also of the university writ large. In my discussions with Professor Popaski over the years, he's often reminded me that in 1953, the first UN Secretary General Lee Malcolm Harsh called his successor, arriving in New York and saying the following words: "Welcome Dag to the most impossible job on this earth." The UN has often been criticized, turned into a scapegoat, when states have failed to live up to its initial expectations. But let us also remind ourselves what Harshal famously said as perhaps a response to this. He said, and I quote him, "The UN was not created to take us to heaven, but to save us from hell." End quote. The Center for UN Studies engages in such projects, study the history and traditions, but also takes a transformative approach to research, teaching, and societal engagement, having in mind the latest geopolitical and technological shifts. The General Society of International Law, which is created under the aegis of the Center for Study of United Nations, under the expert guidance of Professor Dr. Weston Popaski, was founded in 2020, on the 18th day of November, was inaugurated by the Herbert and Rose Professor of International Law, Professor Jose Enrique Alvarez of New York University, along with our dear respected Vice Chancellor, Professor Dr. C. Rajkumar, faculty coordinator himself, Professor Dr. Weston Popaski, and a very dear friend of the Society, Professor Dr. Mohan Kumar. Our fall lecture series of 2021, exploring the ecosystem of international law, builds upon the introduction given to internationalism and international law by the concluded spring lecture series titled Future of Internationalism and International Law. The fall lecture series endeavors to study the different contours of international law. To assist in the study, the speakers will cover and address their respective areas of expertise based upon their years of research and practice. Given the vast ecosystem and the engagement of international law in it, the Society aims to study the fragmentation and fertilizations of various disciplines in this ecosystem. The common denominator in the fall lecture series is to enhance and provide a deeper understanding of international law through international lawyers. With those words, let me welcome our speaker, who is Professor, designated professor, as I would like to classify her, given her expertise in the vast contours of this international law. Monica Feira-Tinta, who is a barrister in Twenty Essex Court, London. She is a specialist in public international law, especially international dispute resolution. She regularly acts on behalf of and against sovereign states in contentious and adversary proceedings, and advises governments, corporate bodies, international organizations, and individuals across the full spectrum of international law. Monica has acted and advised on cases before the International Court of Justice, Court of Appeal, Permanent Court of Arbitration, International Tribunal for the Law of the Sea, UN organs and regional courts such as the ICSID, UNCITRAL, and SIAC tribunals. In addition to counsel work, she accepts appointments as an arbitrator as well. She is currently sitting as the arbitrator in investment arbitration with a seat in The Hague. Monica's scholarly work has also been cited in the World Court, such as in the cases such as Avena and others, the Mexican nationals of the Mexico as the United States of America. She is the author of numerous publications in international law. Prior to joining the bar, Monica worked for international tribunals, including the International Court of Justice. She acted as legal advisor to the State Delegation during the diplomatic conference that negotiated the Rome Statute, which establishes the International Criminal Court. She has also served as assistant legal advisor to the Foreign Commonwealth Office. She holds an LL.M with merit from LSE and was trained by the International Law Commission in all areas of international law under a UN fellowship. She was also awarded the very prestigious Diploma of the Hague Academy of International Law. The Lawyer magazine named her in its Hot 100 list of standout lawyers as the most daring, innovative, and creative lawyers in the United Kingdom in 2020 and was the Barrister of the Year finalist in the Lawyers Awards. She will be speaking today on reimagining international organizations from Glasgow, from the COP26 event. Ma'am, we are honored and delighted to have you in our company. The floor is now yours.
Hello, everybody, and greetings from Glasgow, from COP26. I'm very excited to join today. I'm very grateful for this kind introduction, Ankit, and for the invitation to this series that are certainly, I think, compiling very relevant topics and generating very important discussions around the subject of international law. Today, well, first of all, I just want to remark the following. You've mentioned different topics about international law. I like to emphasize that international law is a system. And so for those who are following this series, you should bear this in mind, that these areas are not separated, self-contained type of topics, but they are important relations between topics, and you will see that that's the beauty of international law. So international law is a unity. And this specific topic I'm going to address, I'm doing that as a generalist with specific topics of interest. So I'm going to ask Ankit to assist me and perhaps put the first slide with the title of today. Right, so reimagining international organizations was the general topic I was suggested to address. And from that general topic, particularly important is the notion of responsibility of international organizations. Now that's a very, if you want, it's a notion that has been evolving and it's been tested recently in different courts. And what I want to do with you today is to pick up two main themes of what is happening concerning the responsibility of international organizations. Two main areas that I believe are key areas for the future of international organizations, and that helps us to reimagine what's going to be like the future when it comes to international organizations operating in different areas as they do under international law. So let's go with the first slide, please. So this is a new, I just saw not long ago, and you may have sometimes seen news randomly. This is from Reuters, and as you can see, it referred to, was published on the 29th of September 2021, and basically, you know, the news is who employees took part in Congo sex abuse during Ebola crisis, report says. So what is the position under international law when there are allegations of wrongdoings, maybe even violations of international law by, for example, employees, staff members of a international organization, what is the responsibility of the international organization itself? Is there any specific rules that allow us to assess what type of accountability is accountability, for example, that this title may be implying? So this is the kind of questions one may pose when thinking about the particular topic of responsibility of international organizations. Let's go to the next, please. Right, so there are two main topics I like to cover today, and I'm going to go in depth into a particular case study to draw from there some, if you want, a state of the law concerning the particular issue. First, I'm going to deal with immunities of international organizations in the first part of my talk. And in the second part of my talk, I am going to deal with rather peacekeeping operations and the responsibility of international organizations in that context. Because this has become a topic of complexity, as you are going to see, and of interest when it comes as to who is responsible for what. And I will try to show to you the extent of, if you want, interlink between what it may be a state responsibility and international organizations' responsibility. So let's first focus on immunities. And here I wanted to think about a case that somehow was interesting for you coming from India, but at the same time, a case that is recent, and it has somehow put the focus again on immunities when it comes to international organizations. So the case is called Jam et al. Versus International Finance Corporation. The next, please. Next slide. This case was decided, recently seen in 2019 by the Supreme Court in the United States. And here is a picture of the World Bank, because the international IFC, let's put it for a short form, it's a branch of the World Bank. So, as you know, the World Bank lends money to states as well as in other contexts for different projects. And we are going to analyze this particular case who touch upon that specifically. So the question is the World Bank responsible if something goes wrong, or in the context of this type of lending money to financing specific projects? Shall we go to the next slide, please? To the next, please. Before to the next. Before we to the next, we are going to go back again. Yes, this is the new. I just wanted to focus. So this is how it came, you know, in 2019. The decision of the Supreme Court. We are going to analyze that and then to draw a specific principles from that. But this is how the new came to be known. You know, US Supreme Court rules that World Bank can be sued. It was all over the news, and therefore, let's see what the case was about. Can we go to the first slide that we were before, please? No, yeah. So let me just move here. Right. So in specifically, the United States Supreme Court ruled against the IFC, or the International Finance Corporation. In this case, that was known as Jam et al. Versus IFC. Now, the case is about a group of farmers and fishermen from India who took the IFC to court over the environmental impact that the project of a power station that had actually been partially funded by the IFC. Now, the IFC is an international financial institution that offers investment, advisory, and asset management services to encourage the private sector development in developing countries. And the IFC is a member of the World Bank Group and is headquartered in Washington, DC, as we saw the picture just before. And whereas the World Bank primarily provides loans and grants to developing countries for public sector projects, the IFC finances private sector development projects that cannot otherwise attract capital on reasonable terms. So next one, please. So the case originally brought before the US District Court from the District of Columbia alleged that the IFC had exercised inadequate supervision of the environmental and social action plan over its $450 million loan to construct a coal-fired power plant in the state of Gujarat, I hope I'm pronouncing this right, resulting in pollution from the plant, such as coal, dust, ash, and water from the plant's cooling system, allegedly harming the surrounding air, land, and water. So you see, this is very interesting, and I like to emphasize right now the following. The case, it was not about the financing the IFC directly affecting the environment, but rather financing private sector's project. And that's interesting because you will see that it's got some relevance later, but that's how complex things may be. Now, the US Supreme Court decision centrally dealt with the defense that the IFC had, which was that the IFC enjoyed immunity. Now, the Supreme Court looked at whether the IFC enjoyed virtually absolute immunity, as the IFC alleged, as foreign governments did when the 1945 United States International Organizations Immunities Act, which we are going to call now IOIA, was enacted, or whether a more limited immunity was applicable in the particular case. Next, please. So this particular act in the United States, and remember this, what is very important if we are talking to immunities is going to be, where is, why was the US relevant? Because it is obviously the headquarters of the organization in question. So now, what does this particular act set? So it grants international organizations the same immunity from suit as is enjoyed by sovereign governments. That's the particularity of the US International Organizations Immunities Act, that it establishes that parallel between sovereign states immunity and international organizations immunity. That's the option that we see enshrined in that particular legislation in the United States. Now, at the time that the US Congress passed this act, the IOIA, governments were entitled to virtually absolute immunity. So the question for the Supreme Court was whether the same as, so that meaning of that term, formulation, was best understood as making international organization immunity and foreign sovereign immunity continuously equivalent. Next, please. So the Supreme Court actually held that the reference in the Act to the immunity enjoyed by foreign governments is to an external body of potential evolving law and not a specific reference to a common law concept with a fixed meaning. So this external body of potentially evolving law now follows the doctrine of restrictive immunity as reflected in the US 1976 Foreign Sovereign Immunity Act. Under the Foreign Sovereign Immunity Act, foreign governments are presumptively immune from suit, but there are statutory exceptions to this immunity. Inter alia, a foreign government may be subject to suit in connection with its commercial activity that has a sufficient nexus with the United States. So remember, commercial activity and sufficient nexus with the United States. Next, please. So as reminded by the US court, this turning point started in the US in 1952. This is a crucial year for the United States. And in fact, I say that what happened in the US eventually also had an impact around the world. But in 1952, with the Tate letter, there was a shift in the position of the US concerning state immunity. So the rationale was that widespread and increasing practice on the part of governments of engaging in commercial activities made it necessary to enable persons doing business with them to have the rights determined by courts. And under this position, foreign governments were to be entitled to immunity only with respect to the sovereign acts and not with respect to commercial acts. Now, however, the US court in this case said that the ultimate purpose of immunity is not relevant to the interpretation of the provision that it was trying to examine at hand. The IFC argued, of course, that the purpose of international organizations' immunity is entirely distinct from the purpose of foreign sovereign immunity. And the Supreme Court, however, held that whatever the ultimate purpose of international organization immunity may be, the IOIA does not address that question. And the immediate purpose of the immunity provision is expressing language that Congress typically uses to make one thing continuously equivalent to another. And may I just say on that why? Because they were obviously arguing that in a way that the immunities of international organizations was different, and it was principally functional, and it just didn't follow the same, if you want, rationale of a state immunity. But you see that the court took a different approach. And next, please. No, sorry. Can I have one back, please? Right. So the court noted that federal courts have often relied on the reference canon, which is a US doctrine of statutory interpretation, explicitly or implicitly to harmonize a statute with an external body of law that the statute refers to generally, in this case, state immunity. So it held that the court held in this case that the IOIS reference to the immunity enjoyed by foreign governments is a general rather than the specific reference, and should therefore be understood to link the law of international organization immunity to the law of foreign state immunity, so that the one develops in tandem with the other. Now, the court also observed that the State Department had expressed the position shortly after the FSIA was enacted, that the immunity rules of the IOIA and the immunity of the FSIA were now linked. It noted that the department had reaffirmed that view during subsequent administrations, and it has reaffirmed it again in the context of the case. And there was a quote there that said the following: by virtue of the FSIA, and unless otherwise specified in their constitutive agreements, international organizations are now subject to the jurisdiction of our courts in respect of their commercial activities, while retaining immunity for their acts of a public character. And let's not forget that in this case, the World Bank branch that we are dealing with, the IFCA, it was not lending money to a state, it was lending money to a private actor. So this US Supreme Court decision, no, back one, please. Yeah, there. So the US Supreme Court decision rejected the defense of absolute immunity invoked by the IFC. So this is a very important and crucial, if you want, outcome of the case, because what the IFC, a particular branch of the World Court, the World Bank, was alleging was that it enjoyed absolute immunity. But the Supreme Court actually concluded that it didn't. Now, a notable and important caveat in the above is the following. The IFC also contended that the interpretation of the IOIA immunity provision to grant only restrictive immunity would defeat the purpose of granting immunity in the first place by subjecting international organizations to suit under the commercial activity exception of the FSIA for most of all of their core activities. And the IFC argued that this would be particularly true with respect to international development banks, which use the tools of commerce to achieve their objectives. So that was the concern the IFC raised. But the Supreme Court held that those concerns were inflated, and for three reasons. And these three reasons are important. The IOIA, number one, provide only default rules. So an international organization charter can always specify a different level of immunity. That's number one. Number two, it is not clear that the lending activity of all development banks qualifies as commercial activity within the meaning of the Foreign State International Immunity Act. But even if it does qualify as commercial, that does not mean the organization is automatically subject to suit under the FSIA requirements, because they also there are additional requirements that has to be met. Next, please. So the court concluded that restrictive immunity hardly means unlimited exposure to suit for international organizations. So remember this. So restrictive immunity, which is what the court concluded applied to the IFC. So this hardly means unlimited exposure to suit for international organizations. So that was the conclusion of the court. So what are the implications for the IFC and other international organizations? So first for the IFC. So the most direct implication of the US court decision in jam et al. Is that the case now goes to trial. So as matters currently stand, no absolute immunity applies to the activities of the IFC. Its immunity is a qualified immunity. Now, being applied a restrictive immunity test, however, does not mean that such restrictive immunity does not sufficiently cover the IFC in the jam et al. Case. So the FSIA includes other requirements, inter alia, for example, that a lawsuit must be based upon either the commercial activity itself or acts performed in connection with the commercial activity. And it is arguable whether the petitioner's suit in this case, which largely concerns allegedly tortious conduct in India, would satisfy the based upon requirement. Indeed, if the lending activity were to be considered commercial, this would not mean that the IFC would be automatically subject to suit, since other FSIA requirements must also be met. And these include the commercial activity must have a sufficient nexus to the United States, and a lawsuit must be based upon either the commercial activity itself or acts performed in connection with the commercial activity. Now, next, please. As the court held, to be considered commercial, an activity must be the type of activity by which a private party engages in trade or commerce. So the lending activity of at least some development banks such as those that make conditional loans to governments, may not qualify as commercial under the FSIA, the court held. In a similar vein, the meaning of commercial under the State Immunity Act 1978 in the United Kingdom, for example, has meant rather activities for profit. Now, further, claims based on tortious activity would not be falling within the notion of commercial activity, as the US court held. Thus, if the gravamen of a lawsuit is tortious activity abroad, the suit is not based upon commercial activity within the meaning of the FSIA commercial activity exception. So basically, you can see that the analysis can be, the new that we saw is very, very sweeping, but once you start analyzing in detail, you can see that matters are far more complex than what they appear in the newspapers reports. Next, please. So if the IFC were to believe that its activities would be impaired by restrictive immunity, the organization's charter can always specify a different level of immunity, for example, by following an amendment. In assessing this, it could at the same time review whether the current existing mechanism to address compliance claims, the Compliance Advisor Ombudsman, the CAO, need adjustments as a dispute settlement procedure to provide an alternative option to judicial processes. And as in the case of other international organizations, even if the level of immunity were to be almost absolute, such level of immunity can be subject to the organization's right to expressly waive its immunity on a case-by-case basis. Now, what are the implications for other international organizations? Now, there is a list of designated organizations under the IOIA. It is beyond the scope of this analysis to examine the position of each and one of these organizations, of course, but the general impact can, however, be assessed as follows. The IOIA grants international organizations such as the IFC, the World Bank, and the World Health Organizations only on a default basis. And this I really stress very strongly, on a default basis. So the charters of many international organizations have broader immunity than that what is reflected in the IOIA. So the first point of analysis for any lawyer looking at what specific immunity an international organization may have is its own charter. And who is the master of the charter is actually the organization itself, meaning that sometimes charters may be amended. So the United Nations is one of those organizations that have broader immunity than what is reflected in the IOIA. Its immunity provides, so next please, yeah, here. That's the last, the last item you can see. The immunity of the United Nations is the following. The United Nations shall enjoy immunity from every form of legal process, except insofar as in any particular case it has expressly waived its immunity. So you can see how broad is the immunity of the UN. Next, please. Now, the headquarters agreement of the Organization of American States is another example of broad immunity. It affords the OAS full immunity from judicial process, thus going beyond the usual United States practice of affording restrictive immunity. And some international organizations have adopted the immunity standards applicable to the UN specialized agencies while keeping its own privilege and immunities under its constitutive charter. So for example, the International Monetary Fund, as constitutive charter articles of agreement, sets forth the privilege and immunities which members have agreed to grant to the organization and to which all members have agreed to give effect under the respective domestic laws. So the IMF has currently about 188 member countries. And in November 1947, the IMF entered into an agreement with the UN, which sets out the terms of the relationship between the IMF and the United Nations. And under this agreement, while the IMF is a specialized agency within the meaning of Article 57 of the UN Charter, the relationship is one of mutual association between independent entities and not one of principal and agent. In 1949, the IMF Executive Board saw merit to have the Specialized Agencies Convention applied to it, as it was thought that this would facilitate and harmonize the administration of immunities in member countries that are parties. So as noted by commentators, in doing so, the fund also considered that the convention in some specific areas provides for an expansion of privilege and immunities, and it was deemed that this would be in the interest of the fund. So Article 3, Section 4 of the convention states, the specialized agencies, their property and assets, wherever located and by whomsoever held, shall enjoy immunity from every form of legal process, except and insofar as in any particular case they have expressly waived their immunity. So you can see how broad the immunity of specialized agencies is. Now, the International Bank for Reconstruction and Development, the IBRD, also known as the World Bank, is also a specialized agency and enjoys the same immunity as the immunity that we have just seen. Now, the decision of the US Supreme Court has no bearing on such specific provisions enshrined in the constitutive charters of such international organizations. And that's quite important because, so you saw how big the title was of the newspapers, and now you can see how, when you examine that, this is far more complex. Next, please. So for those international organizations who do not have such level of immunity and which may feel that restrictive immunity may affect the functioning of the organization charter can always specify a different level of immunity by introducing an amendment in accordance with its governing rules. So possible changes in the charter of international organizations operate against the background of general rules of international law. And here I make an emphasis because we see that there's a trend right now towards accountability of some sort. So the trend to recognize as a general principle of the law of nations that international organizations are liable for their own unlawful act, just as states, especially towards private persons, is to be emphasized or noted. So the International Law Association, established in 1998, there is no reason at all why international organizations could or should not be held accountable for disadvantages and repercussions resulting from their acts or omissions, and normally based upon the authority and power granted to them. So the issue of accountability, which entails consent and correct fora, is distinct from the topic of immunities, which is a procedural bar in a specific fora, of course. However, that bar obviously is this procedural bar is the gateway, you know, to get to international responsibility itself. Next, please. The UN itself, for example, has acknowledged as an element of international legal principles liability for damage attributably caused through unlawful action by UN peacekeeping troops. A dispute resolution body, the Local Claims Review Board, was created specifically for this. So the possibility of establishing dispute resolution organs or considering waiver on a case-by-case basis addresses the issue of responsibility. So as a conclusion to this first point of discussion, I'd say that the IO provides only default rules. You know, we saw that from the US case. So this particular act provides only default rules. An international organization charter can always specify a different level of immunity. For example, amend this charter. Some international organizations have adopted a hybrid approach, becoming specialized agencies of the UN because they like perhaps the very broad immunity applicable to specialized agencies. Further, it's not clear that the lending activity of all development banks qualifies as a commercial activity within the meaning of the FSIA. Tort claims are excluded from the commercial activity requirement, and this remember very well. And finally, even if it does qualify as commercial, that does not mean the organization is automatically subject to suit, since other FSIA requirements may also be met, such as the nexus with the US, etc. So those were the conclusions concerning the particular case of Jam et al. And I think it's important. What I've done for you is I have done an in-depth analysis so that you can see. You have to remember, first of all, it is clear though that we are moving towards accepting that there is restrictive immunity. There is no such a thing, an absolute immunity for international organizations, as we saw in this case. Obviously, that is going to be qualified, and you have to take into account a number of things. So specialized agencies of the UN, you have seen how broad the immunity is. But the tendency of international law is towards actually analyzing in a very close manner issues of accountability. And certainly, even if issues of accountability cannot be seen by courts, the international organization itself is going to be put under pressure because of these developments to have some level, some mechanisms of accountability embedded in its own, if you want, functioning. We are going to be seeing yet what is going to happen now, continuing with the case. There is also another case that came from Honduras that also is relating to IFC. But you can see that it was an entire revolution. I mean, at the moment that this decision came, it came as a real surprise to the World Bank, and a kind of reassessing the state of play and reassessing the state of immunities of international organizations. But you can see that environmental issues, for example, have becoming quite important as well, and accountability for harm arising in that context was at the center of this Jam et al. Case. And you may be even more familiar with the situation, what happened in Murajat. And as I have explained at the beginning, the issue in that case was not really that the IFC directly had committed any wrongs, but rather that it had lent money to private actors, and it had not, if you want, overseen what these private actors were doing, whether they were applying the protocols and were acting in compliance with the standards that should be applied when it comes to environmental international law. But you see how interesting and complex things may be, because you have, on the one hand, immunities, on the other hand, the law of international organizations, on the other hand, you may have issues of torts, on the other hand, you may have issues of environmental law. And this is what I was saying at the beginning. International law is a system, and when all these areas come together, you have to see the right connections and how they all are interconnected so that we have a solution in a particular case. Now, moving away from immunities, we have just seen something referred to peacekeeping operations. I want to bring you to the context of peacekeeping operations, because as we know, international organizations are active in this type of scenarios. And I want to bring a very interesting case to your attention, which was decided last year, which is the Tomanovic case. Now, let me just say the following, first of all, about this case. We are seeing an increasing level of complexity when it comes to peacekeeping operations, because it is not just that an international organization or even an international specific peacekeeping operation may act, if you want, in a detached manner. But rather, what happens often is that states give lend, its forces to, because obviously international organizations themselves don't have armies. So states that are parties to these international organizations may give the actual personnel for the operation. But to adapt to that complexity, sometimes it's not just that, because if it's that, then it's directly under, if you want, the control of the international organization. But sometimes it's even more complex, because it may be that personnel are seconded. That means that the state continues. There's a link, if you want, seconded personnel that is just sent to that specific operation. And there it could be adding, another level of complexity to who is responsible if something goes wrong because of the acts of omissions of that person that has been seconded. And that's precisely what happened in the Tomanovic case. And let me tell you what happened. So this was a claim that is related to the United Kingdom. So it was decided in the courts of the United Kingdom. And basically, it was a claim brought by family members of 9 individuals that were tortured, killed, or disappeared in Kosovo between June 1999 and July 1999, and in one case in March 2000. And their relatives of these individuals brought a case against the FCO, the Foreign Commonwealth Office, in English courts. Now, the claim of, in this case, was not alleging that the FCO committed these violations, say the torture, the killing, or the disappearance, but rather it was brought against the FCO for failure of the defendant, of the FCO, a public authority within the meaning of Section 6 of the Human Rights Act 1998 by its employee, Mr. Rattel, to carry out, whether properly or at all, the office of Chief Prosecutor of the Special Prosecution Office of the Republic of Kosovo. So let me just pause there. So what was this? Right, so after the situation in Kosovo, where there were obviously an intervention and issues that were unfortunately of the type of I'm just describing, like people that were killed and disappeared. There was a peacekeeping operation, and as part of that, there was establishment of prosecutions and of investigations. Now, in this particular case, the chief prosecutor of this entity was a seconded person that had been seconded from the Foreign Commonwealth Office to carry out those specific tasks in the Republic of Kosovo. Now, and that was as part of that specific international organization's activities. Now, next, please. The central issue in the claim concerns really the manner in which a member of the mission, so the secondee, discharged tasks at the court of the mission. This mission was called EULEX. So it was a mission within the context of the European Union. So the European Union, if you want, is the international organization, and the mission was called EULEX. So the task in question was the task of EULEX. However, the person that was supposed to carry out the tasks was the secondee, the chief prosecutor, who had been sent by the FCO. Next, please. Now, so a question to be asked oneself is, can this conduct in question be attributable to the UK? In particular, is to think about whether these acts, prima facie, could be considered acts of the UK, acts of an executive organ, of a state that had been contributed to that mission. So this is how complex it is, because you see, you have a mission, EULEX, from the EU, but the specific member states are the ones that are contributing with their forces to the mission. Now, when you have secondees, is a secondee under, if you want, the control of the international organization, or is a secondee under the control of the state that has contributed to that mission? Now, the responsibility for the actions or contingent members of a mission cannot be simply passed on to the contributing state as the claim purported. So this is important. So there are some rules that are playing here. So what are those rules? It is the exercise of effective control upon the conduct, which is crucial in accordance with rules of international law. So the claimant alleged test of full command, direction of control. This is what the claimants were arguing, that really who had full command, direction and control upon that secondee was the FCO and not the mission of EULEX or the EU. And they argue that the test was full command, direction and control. They said, he's been paid by the FCO, etc., etc. So that is all demonstrates that the link is really with the FCO and not with the international organization. However, this test of full command, direction and control has no basis in law. Next, please. So I don't want to give too much background about the EULEX itself. It suffices to just remember that it was a mission. And I rather want to focus on the rules themselves of responsibility under international law. So first of all, I want to remind you that perhaps emphasize first of all that the important issue in this case is going to be attribution. So you have to be clear to apply the test for attribution. Who are we going to attribute those acts or omissions? If this gentleman did his job well or did not do his job well, who is the ultimate responsible for that? How does the rules of attribution under international law operate in this case? Is it to the state that had lent these forces, or is it down to the international organization itself? So now, leading commentators note that the decisive element for allocating responsibility either to the contributing state or the international organization is the de facto command and control at the time the act was carried out. You see, and this is very, if you want, tricky, because it is fact sensitive. It will depend on the de facto command and control at the time the act was carried out. Now, the International Law Commission draft articles on the responsibility of international organizations, the ILC draft articles, refer to this decisive element as effective control. So effective control being the key. Article 7 of the draft articles state, can you go back, please, one? Yeah, that's it. So conduct of organs of a state or organs or agents of an international organization placed at the disposal of another international organization. This is specifically the situation where we are. The conduct of an organ of a state or an organ or agent of an international organization that is placed at the disposal of another international organization shall be considered under international law an act of the later organization if the organization exercises effective control over that conduct. This is the key to resolve the conundrum in the Tomanovic case. But you see that the rule is clear. But how does that apply then? Let's go next, please. So the International Law Association referred also to this effective control as operational command of control. And now the test to be applied is not a general one. Instead, the concrete act or a specific conduct must be examined as to whether it was carried out under the factual control of the organization or the actual control of the sending state. So such a conduct can be carried out either by international contracted staff or a staff seconded from another subject of international law, either a state or another organization. For seconded staff, the command and control test is particularly important. They're only de facto integrated, so the seconded staff are only de facto integrated into the international organization that is placed at the international organization as an organ of a state or as an organ or agent of the international organization that is placed at the disposal of another international organization. They are, as a result, functionally but not institutionally part of the organization. So this is the complexity of the seconded personnel. So they are functionally but not institutionally part of the organization. So under principles of international law, conduct is to be attributed to the seconding state if the seconding state exercise effective control over the conduct in question, which, as seen above in the context of peace-building missions, is the factual command and control at the time that the act was carried out. So in the instant case, the ULX prosecution and judiciary neither investigated, adjudicated in the name of the contributing states, nor applied their legislation. The relevant CSDP ULX acts as union law defining, and so all of that was carried out in execution of a peace-building mandate. So attribution to the EU member state is ruled out, as these CSDP acts are not implemented by the EU member states. So in this particular case, Mr. Rattel discharges his functions through a mandate given by the European Union under specific competences that the European Union had established. So if we go next, please. Next, please. So in Behrami and Salamati, before the European Court of Human Rights, it was held that the international organizations retain, when the international organizations retain ultimate authority and control, the conduct was to be attributed to the international organization. However, in the case of Al-Jeddah versus United Kingdom, which came after Behrami and Salamati, the court adjusted its approach, applying the attribution test set out by the International Law Commission, the effective control test. So in this particular case of Tomanovic, either under the Behrami and Salamati case test or under the Al-Jeddah test, conduct in this case was not attributable to the UK governmental organs. And that's exactly what the court decided in this particular judicial review that was brought against the FCO. So this analysis, as you see, obviously there was a far more level of complexity in going into specifically, how the ULX operated, et cetera, But I think in black and white, this is a very important conclusion, and this slide that I just showed you is key. Because it shows you where we are in the development of rules concerning attribution when it comes to international organizations that are operating in specific missions where states are contributing with personnel to those missions and sometimes with personnel that is borrowed, if you want, and is not actually permanently part of that mission. So in short, you can see that peacekeeping operations and issues going wrong in peacekeeping operations are a continuum, are a never, a situation that is a constant, particularly because of how we have seen in the last 20 years, obviously interventions of a use of bellum sort, and following those interventions, there has been peacekeeping operations. So in the international law milieu, we have seen far more activity of states in that sense. And I think I want to emphasize that this is how complex international law can get. If we are thinking about the UK alone, in the past, the UK didn't have this amount of cases raising international law issues. But we are having more of that because of the last 20 years of state practice in different scenarios, including in the context of peacekeeping operations. But I think this case is extremely instructive to show you in what way things can reach complexity. But also, I believe I am able to show certain clarity as to how the rules apply. But these rules are going to apply to specific facts. So it's going to be fact sensitive. And to a great extent, one has to be extremely careful in analyzing those facts. So I conclude with this, my presentation. I know that I have thrown here extremely complex notions. I have tried to be systematic in presenting them to you via the gate of two specific examples that then allowed me to make some general conclusions in both areas concerning responsibility. One area was in the context of peace, and it came basically via a procedural bar to hold an international organization accountable. And the other example, I was rather dealing with peacekeeping operations and issues of attribution. So it's pure international law. How does that actually work? And I stop here, and I like to take some questions, if there are any, to have a little bit of discussion. Thank you.
And let me begin by thanking you for giving us this powerful tour of immunity, a topic which is extremely close to my heart, and studied it in different lights and perspectives as well, and on issues and cases which are close to India, such as the Enrique Alexi case. Events after that, there is also a current case in the Delhi High Court, which deals with the Spanish embassy and a commercial contract which they entered into. I have a couple of comments to make, but in the interim, let me request the participants to also share their questions and comments on a very engaging topic. The European Court of Human Rights was mentioned. Now, I've studied this in depth, the court in depth, especially the origins of this court and the instrumental role that Winston Churchill played in creating the European Charter for Human Rights, which later became the European Convention on Human Rights, and then created the Tribunal. So I just wanted to share this, and that this work of Churchill and the presentations which he gave at the University of Switzerland all those many years ago. International law as a system or a set. Whilst Professor was speaking, there was an article published on the blog of the European Journal of International Law, which speaks exactly about this. So I'll read out the introductory part of that because it's extremely illuminating. The author is a professor of law, a judge at the Newman Scholar at Rutgers University. He says, international law is a system, not a random collection of norms. So concluded the International Law Commission's study group on the fragmentation of international law in 2006. Legal philosophers immediately recognized the target. In a footnote to their full report, the study group named him. The view that holds international law is a primitive structure bases itself on the claims that the rules of international law do not form a system, but merely an aggregate of primary rules that states have contacted. And the person here is H.L.A. Hart. The author adds to this, and after this I'll close this point. Why did Hart say that the rules of international law constitute not a system, but a set of rules? Was he right? In his wonderful book, Philosophy and International Law, Critical Introduction, David Lefkowitz offers a new reading of Hart that is simple and powerful. If David is right,
may I stop you there, Ankit, because you are there. You are touching a sensitive point. Okay, obviously this is not going to be a last say on this, but I started my intervention by emphasizing that international law is not just rules without any connection. So when I talk about a system, I mean there is a normative environment. I mean that there is a hierarchy as well. I mean that there is a connection between rules. So there is harmony. Let's put it that way.
I completely agree with you over there.
Yes.
And I was waiting for you to jump in and intervene, because this is a discussion which is very close to persons of you and your ilk. The other points that I want to make, and I'll encourage questions, and I'll frame my next comment as a question as well. There's an article which I'd written a couple of years ago now. This was on the members of the Permanent Court of Arbitration and the sole arbitrator was Max Huber, who deconstructed sovereignty in the Las Palmas case. He observes and highlights the sovereignty and independence of interdependence of nations. Sovereignty or independence of nations, according to Max Huber, in practicing international relations, is a right to exercise therein, to the exclusion of any state, the functions of a state as well. The development of national organizations or states during the last few centuries, as a corollary, the development of international law has established the principles of exclusive competence of the states regarding its territory in such ways as they are many cases in which states have claimed their right to law enforcement abroad. But non-consensual acts also gather attention. What about acts such as Nazi criminal persecution of Eichmann in Argentina by Israelis in 1960, or the sinking of the Rainbow Warrior by the French agents in New Zealand, remain a long-standing and long-lasting memory in this discourse. So how does one lay a case of immunity? This is the revamping of the question.
Yeah, but no. With here, you are confusing a number of, these are very separate issues, what you are raising, because what you've been mentioning with Eichmann, etc., is the use of some kind of extraterritorial, if you want, application of justice, say in the Israeli case, and it raises the particular case of Eichmann, let's say, is really about universal jurisdiction. So the topic there, my dear friend, is jurisdiction, and our topic here is international organizations.
Yes, that's correct indeed. Let's look at UN peacekeeping in sexual abuse cases and the fate of Catherine Bolkovich, the former monitor of the United Nations International Police Task Force in Bosnia and Herzegovina, who was exposed to trafficking ring in which the UN personnel were responsible for trafficking young women from Eastern European nations.
Well, yes, absolutely. So I think that I wanted to start by throwing some headlines that could show to what extent, if before we used to have the view, and I have given the examples of some international organizations having such nearly absolute immunity, other than waiving case by case. And usually that would be the first step, isn't it? Because it's not the purpose of international organizations to be doing what you just mentioned. So when there is a matter like that, I mean, the first thing is an invitation for the international organization, if it's one that has such a broad immunity, to actually waive the immunity so that the case can be investigated. And certainly there is no reason why that international organization shouldn't waive that immunity. But you will have to start, as I presented today, by analyzing what immunity does that international organization specifically has in its constitutive document. So once you look at that, then you can go, what is the default position? And the default position may be dependent on where that organization is headquartered. It may be, in the US, it may be in the UK, it may be somewhere else. So there's a number of layers there to actually analyze. And even in some contexts, the complexity even be added, because in some situations, it's not the staff of the international organization itself, but it may be that actually some contributing states, have lent the particular individuals to the international organization, and that's where Tomanovich principles, come to play, because actually you will have to see were these the acts, that were all under the effective control of the international organizations, or were this something else? And the examples that I gave of the European Court, it helps you to see how there is an evolution as well in the understanding even of international courts in determining responsibility. And obviously the work of the International Law Commission is extremely relevant, illuminating and clear about codifying these principles. And we are going back to this topic of systemic, because that's particularly what the ILC has been doing, is to bringing together and codifying the principles that allows us then to see the rules in a clear manner.
So let me give you an open-ended question then. Is this a vitiation of sovereignty or an evolution of sovereignty? Are states understanding sovereignty better in terms of then thereby reducing immunity, which at least initially came as a blanket immunity, or?
Well, but this is not really about sovereignty, because we are not, although, yes, you may have been confused by the manner how the American legislation, if you want, dealt with international organizations' immunity. You shouldn't be confused by that manner. Here, we are not talking about state immunity. We've been talking about international organizations' immunity, which is completely a different notion. And I'd say that here, for example, in the UK, those two types of immunity are treated separately with no connection. Whereas in the US, they had a different approach. So in our case here, we are not really talking about sovereign issues of sovereignty of states at all. These are international organizations have personality under international law in its own right, not because they were formed by states, but in its own right. And that is something that I like you to have clear, all the participants in this conference today.
You've highlighted the American jurisprudence, and of course, there's sufficient material on the other side of the Atlantic as well, specifically with reference to the UK. You highlighted a sufficient nexus in commercial activity as to paradigms to assess this, and there are others in the UK system as well. My question to you is,
but that, so what I analyzed is or the US, they link that unfortunately to state immunity like a parallel, and that's why all this idea of commercial activity, etc. The way the UK legislation approached the immunity of international organizations is completely separate, completely different. So I just want to make that emphasis
Yes.
because that analysis applies and pertains to, you see, how can I put it? There are only two ways to eventually hold an international organization accountable. Either you may be in international court when that's possible, you know, when there is forum for that, or you do that in domestic courts. So when you apply international law via domestic courts, then there's going to be, particularly in countries that enable legislation in connection to international law, you will have to do that via legislation that has been enabled in that particular jurisdiction. That's why it's like bringing international law through the funny kind of little hole, keyhole of the domestic legislation. And so sometimes international law there doesn't look quite like international law, but what is going to help us understanding how that legislation should be interpreted are principles of international law. But this is how complex it is, you know, is international law can come in a pure form before international courts, that's great. But to our, to add complexity, international law can come in shapes, like kind of twisting itself and adjusting itself to go through the keyhole of domestic legislation, and eventually, you know, courts having to grapple with, if you want, with these principles of international law in interpreting their own legislation and resolving a dispute. I see a hand here up. Why don't we take that question? Yes, Saurabh.
Yes. Yes, Professor. First of all, it was a great session. I just like to compliment. This is a very knowledgeable session, and especially in the Forum International. One question which I want to pose here is, now that we know that how different domestic jurisdictions interpret the concept of the very concept of immunity on international organizations a bit differently. Now, you also mentioned that there are two ways how these cases can be dealt, either brought to a pure form, in a pure form to the international court itself, or through the domestic legislations. My point here to make is that what is the most, according to your opinion, the most fruitful bearings of it? Because we know if the whole liability of it is shifted to the international court, they'll obviously want to retain as much of immunity they want to retain, because it also aids in kind of their future ordeals. But you know, domestic legislations are more prone to holding certain organizations liable. So if we go via the domestic route, I know there can be altercations, as you mentioned. It will be like, you know, going through its tiny keyhole to a big forum of international law. But I also believe, Professor, that would be, you know, more keeping the organizations in check. Although it will also result into different interpretations of the same law, different levels of immunity. So every nationality dealing immunity in different matter, for example, different aspect, and which will be a bit complex for an organization which have to deal with different, you know, bodies at once. But won't that be the more, check and balance system than international organizations having brought it to their own international courts?
Yeah, okay. A very interesting question. Look, I mean, I am a practitioner, meaning an international law ultimately is a living thing, meaning that it's not just a theoretical body of law. And I like you to go away from this lecture with the idea that international law is out there to finally resolve, you know, issues. And so from that angle, what is important is remedies. So whether you are, if you are looking at this from the point of view, let's say, of the victims or of those affected, as counsel, let's say, you're not going to kind of say, okay, the solution is I go to this because I like international organs better. I'll try to see where that's possible. No, you go to what is possible, because the key thing is remedies, and you will take into account the situation, you will analyze, and you will look at the different avenues, and you will advise your client to go to that forum that is the most viable and most practical, and the one that has less hurdles. So So that's usually international law will have different avenues, different solutions. And the more you know on international law, the more you are going to see that there are several avenues. Now, when it comes to international organizations, I mentioned this, the headquarters are quite important. So it's not going to be just a constitutive instrument, but also possibly you will have to analyze where is the headquarters of organizations. And organizations have thought very carefully as to where the headquarters are. So usually those forums are going to have already sophisticated case law. It's not going to be that courts are, not sophisticated, but rather the opposite. So I don't think that this issue of fragmentation that in a way you are raising, that you may have contradictory types of decisions and approaches around, it may be a problematic. Because if you think about the common law, for example, the common law is very often the case that courts, if there is no precedent, they are going to look at precedents in other common law jurisdictions, as well as obviously international law principles themselves. So I don't think that there is such a lack of, if you want, a cohesive development of that jurisprudence. So I would say that yet, though, it's right now in a state of constant development, because as we see, new situations are coming to be brought before courts. And this is the issue of a law continuously being evolving. However, I don't think that this law evolves without a framework. This law evolves clearly within framework. And I would say that cross-fertilization is always present. Particularly when we are talking about, in the case of common law jurisdictions, this, if you want, the constant dialogue between different courts, is there. Yes.
Thank you so much, ma'am. I think we've extended beyond our stipulated time as well. We will not hold you for very long. Thank you so much for joining us. It's been an honor. I'm fully aware you have other commitments as well. Final words, and then we can close.
Thank you very much for that. Yes, indeed. I am right now going to a panel of Pacific Island states starting shortly. It's been a real pleasure to be part of this conversation today. I particularly wanted to pick an Indian case because it really made headlines, and I hope I have given you a little bit of food for thought. And also you all as future international lawyers from Indian nationality, please do reflect on the future as well of and really look up as to what India is doing internationally, including in the area of now climate change and the key aspects of what we consider will be the future of the world, because the lawyers that will be advising and shaping that future and that law are obviously also formed by all of you. So congratulations for this series, and please, I'm looking forward to see what further steps you are taking up after the series ends. Thank you very much for today, and all the best with your work and your studies. Goodbye for now.
Thank you so much, ma'am. Thank you. Thank you everyone else also for joining. We'll not hold ma'am for very long. She has to go and plan how to save the world. Thank you.
Thank you. Bye-bye.